Do you have a deposition coming up? Are you so stressed and nervous that you cannot sleep until the date of your deposition? Let's talk about how you can prepare for your deposition so that you'll be less nervous and more in control of your deposition. Let's dive in. Before we proceed with this video, I wanted to remind you and let you know that I completely understand that deposition is very, very stressful. That's why it's important for you to still go ahead and talk to your lawyer before your deposition. Preferably 1 to 2 days before your deposition, not the day of your deposition. Go ahead and contact your lawyer and try to arrange a meeting so that you can be properly prepared for your deposition based on the facts of your case. Now let's go ahead and check out the rest of my tips for you to hopefully help you as well. Hi there, my name is Katherine. I'm a lawyer and I think differently. Before you can properly prepare for your deposition, you'd want to know first the basics of deposition. That is, who, what, where, when of your deposition. In my other video, I talked about all of that and I will put the link in the description below. So if you're ready and whenever you want, you can go ahead and review the basics of deposition. In this video, we'll talk about how to actually prepare for your deposition so you can be calmer and more in control at the time of your deposition. I will give you 3 tips that will help you feel more zen-like and in control. So let's dive in. The first tip is, what do you know and remember at the time of your deposition? Your deposition usually takes place months or even years after the car accident. No one will expect you to remember every single detail. I don't even remember what I ate for breakfast last Monday, let alone what happened 2 years ago. So relax, you don't have to remember all of that. This is not a memory test. For example, most people don't testify and say, the accident happened at 3:58 p.m. and I was driving 47 miles per hour when the other car hit me. Nope, that actually sounds rehearsed and sounds like you're lying. What most people say is, the accident happened around 3:30 p.m. I was driving approximately 45 miles per hour when the other driver hit me. That sounds more realistic, right? You also don't need to review any of the documents like your medical records, the police report, or even your diary where you wrote all of what happened before and after the accident. Nope, nope, nope. If the lawyer is good, then he or she would have that information in front of her or him at the time of your deposition. And if they ask you a question that you don't remember, if the lawyer is good, the lawyer will ask you, will the police report jog your memory regarding that particular fact? If you say yes, then the lawyer will show you the document. If you say no, then no. But if you do say yes and the police report is shown to you, you read it and then it does jog your memory, then say, yeah, oh, I remember now. I was driving 45 miles per hour at that time. Or you look at it and it still doesn't jog your memory, then just say so. Nope, sorry, I looked at it. I still don't remember specifically. The accident was too chaotic and hasty and I just can't remember what happened. That's perfectly fine. The rule is you provide your best testimony at the time of the deposition, not 2 years ago or in the future at the trial. It's at the time of the deposition. What do you remember? Here's something you must remember and very important. Do not, under any circumstances, make up stuff because you want to look smart or you don't want to look stupid. Nope, nope, nope. Do not make up anything because if you make up something, it means you're lying. If you're lying, that means you lose. The second tip in preparing for your deposition is to know that your deposition is not the time to win your case. If you try to win your case, you will lose. In my other video, where I talk about the basics of deposition, I mentioned the purpose of a deposition. You need to understand why your deposition is being taken. One of the reasons why your deposition is being taken is for the other lawyers to evaluate if you're going to be a good witness or a bad witness. Consider your deposition as a trial run or a test run as to how you will testify at the time of trial later on. So, at your deposition, if you're going to be a good witness and you're calm, you answer the question properly, you appear credible, then the lawyers watching you will say, oh my gosh, he or she is a good witness. That person will testify the same way at trial and the other lawyer will be scared of you. Yes, scared scared of you because you will be credible and the jury will actually believe you at trial over their client. When I used to be a defense attorney, the very first thing that insurance company would ask after I take the deposition of a plaintiff or someone who was injured in a car accident is, will that person be a good or a bad witness at trial? So as you can see, it's very important to try to control yourself at the time of the deposition and be a good witness as opposed to trying to win your case. Because when you're trying to win your case, you start coming off as a bad witness. You might start arguing with the other lawyers. You might start hiding, or you might start omitting information, or you might start yelling, or just appear as if you're lying or not credible. If that happens, then you will be characterized as a bad witness, which means that they will be encouraged to go take your case to trial because they know you will act the same way at trial, and then the jury will believe their client over you. So remember, at the time of your deposition, that's why it's not the time for you to win your case. It's the time for you to show them that you will be a good, credible witness at the time of trial later on. Another reason why your deposition is not the time to win your case is because the second reason why a deposition is being taken is to gather information. Based on your testimony, the other lawyers will gather information from you. They will get names, dates, locations, or any other information that might be useful for their investigation. For example, if you mention that you saw Dr. Smith for your back injury, then they will go ahead and request your medical records from Dr. Smith. If you say that there was a witness at the accident scene and his name is Joe Schmo, then they will go ahead and contact Joe Schmo and try to find out what he remembers about the accident. That's one of the reasons for a deposition. So if you're trying to make things look better than they're supposed to be when they're not, the other lawyers will find out because based on your testimony, they will dig deeper and investigate more as to what truly happened and everything else you testified to. Keep your answers simple and straightforward and just answer the question. The third tip I have for you is the most important one. So you really have to listen and pay attention, because if you remember this, then you will feel less nervous at the time of your deposition. Are you ready? Are you listening? The third tip is you are in charge. Yep, who is in charge at the time of the deposition? You are. Why? You are the only one creating evidence. You are the only one under oath under penalty of perjury. You are the only one providing testimony that is evidence for this case. No one else can make you come up with evidence. Not the lawyers, not the court reporter, not the videographer, not anyone else inside or outside of your deposition. Only you. If you remember that, it will create a mindset shift because now you know that you are in control of your deposition. What does that mean? That means the lawyer who's asking you question is not in control of your deposition. Even your lawyer is not in control of the deposition. The other lawyers and the court reporter, none of them are in control of that deposition. Only you can control how the deposition will work. What does that mean? It means that if you want to take a break, they all have to take a break. If you want to eat because you really need some energy, because now you can't provide your best testimony because you're hungry and you're now getting lightheaded and dizzy and you need to eat, everyone else has to take a break. And if they say, no, you can't take a break, then tell them, I'm hungry, I'm getting dizzy and lightheaded. For sure, they will stop the deposition and have you eat because they don't want to take your testimony if it's not your best testimony. If you need to go to the bathroom, everything will stop and they'll wait for you. If you don't understand the question, say, I do not understand your question. Can you clarify that, please? The other lawyer will have to do it because, again, they want your best testimony. They don't want you to answer a question if you're confused. What if you say, I don't understand your question, I'm kind of confused, and the other lawyers say, oh, well, tough luck, just say something, then whatever you say won't be any help for that lawyer, because the judge or the jury will say, well, she was confused, so what was that testimony about? As you can see, you are in charge. You can say, I don't remember, and it's fine. You can say, I don't know, and it's fine. That way, when you know you're in charge, you feel more in control. You can walk into the deposition knowing that you're in charge, and you will tell everyone else how you want the deposition to go forward. Because remember, as I mentioned in the first tip, this is the time for them to figure out if you're going to be a good or bad witness. And if you feel in control and in charge, that will come out as confident, and you will look confident on the video recording or even on the transcript that the court reporter is transcribing. And then the other lawyers will see you and say he or she is in control of her or his testimony, and they know that you're going to be a good witness at trial. I didn't come up with that mindset shift. I just want to give kudos to a good friend of mine who's an excellent attorney at preparing witnesses for deposition. His name is Matt Clendenin. He's the one who always points out that the person being deposed is the one in charge. So this is so important that I want you to repeat after me. I am in charge. And if you got to this part of the video, please go ahead and type in the comment below, I'm in charge, so I know that you got to this part. Now let me tell you 2 other things that you need to know that will help you get an edge at your deposition. At the time of your deposition, you might hear objections. For example, when the other lawyer asks you questions, the other lawyer might object. They might say something like, objection, irrelevant, objection, asked and answered. Something like what you see on TV or in the movies, right? When you hear that objection, don't get frazzled, don't get nervous and confused. Don't lose sight of the fact that you're in charge. Know what an objection is. An objection is something that lawyers have to make on the record, which means they have to have the court reporter put it on the deposition transcript, because later on at the time of trial or when it becomes necessary, the parties or the lawyers will discuss their objection that was on the record to several years later at trial with the judge. So the lawyer and the judge will discuss it several years later. The objection has nothing to do with you. It will only have something to do with you if the objection is something that by law requires you not to answer the question, and usually that's privileged or privacy reason, and you'll know if you are not supposed to answer the question because your lawyer or the other lawyers will say you don't have to answer that question. And also, objection is not for you. The objection is actually for the lawyer asking the question. The other lawyer who is asking the question did something wrong when he or she was asking the question, and the other lawyers are pointing it out to that lawyer. Another thing that will give you an edge for your deposition is know what happens after the deposition. After the deposition, you will receive what is called a deposition transcript. That is what the court reporter was typing the entire time during your deposition. The questions, the answers, the objection, when people took break, when people got back from break, basically all the discussions on the record, meaning when the court reporter was typing it out. The deposition transcript could be thin or thick depending on how long the deposition is. What you will do then is you will read the deposition transcript and make corrections. However, be very careful, because if you correct something substantive, let's say you testified that the light was green when you went ahead and started driving into traffic, and then you read the deposition and you change it to red, that you actually ran the red light, then that's a very substantive or very important testimony that will reflect badly on your credibility. But if you're just making changes as to typo or misspellings of names or typo with the numbers, that's perfectly fine. You can make that kind of corrections after you review your deposition transcript. The deposition transcript too, you'll notice it's a question and answer format, kind of like when you're reading a play. And just remember, when you're testifying, don't make jokes, because that does not translate well in the deposition transcript. When you're reading a joke, it actually doesn't come out as a joke. Don't also try to be cute at your deposition when you're testifying, and don't try to make snarky or sarcastic comments, because you might feel good at the time of that deposition thinking that you made a sarcastic sarcastic comment and had a good comeback against the lawyer who's trying to aggravate you, only to discover that when you read the deposition transcript, it looks bad on you because now it's out of context and, people's intonation are not really put down in deposition transcripts. That's why those kind of things don't translate well. Just answer the question properly and be a good witness as you can. Now you know how to prepare for your deposition. Again, if you want to know the basics of deposition, what is a deposition really, and all of that, go ahead and check out our other video. The link will be in the description below. Also, if you want to know what happens next after your deposition, what are the 3 stages of the process after a car accident, we also have a video for that, and the link will be in the description below as to what happens next after a car accident, because there are 3 stages that you have to keep in mind. Now, you know how to prepare for your deposition and you're ready for your deposition. Just know you can do it. Remember, who's in charge? You are. If you learned something new from this video, please go ahead and click subscribe. If you've seen my other videos, you know that my son created this for me in support of my YouTube channel. So please go ahead and click subscribe right there, the red button. Click it now. It will help our channel go ahead and make more videos like this to help you and other people who needs information like this. Thank you so much. Have a nice day.